Tonight on MGT 325, we will be covering a case about death, alcohol, and contracts. The Snyder versus Viani case decided by the Nevada Supreme Court in 1994. To help go over the case and provide details, let's welcome Joseph Viani, Shauna Snyder, and John Medrosa. We also have a surprise special guest appearance from Mr. Levette himself, live and in person from the afterlife. Good morning, Mr. Levette.
No sense of time up here in the afterlife, but good morning, Gene.
Mr. Levette, I want to cut straight to the chase. Let's go back to July 13, 1990. Do you recall that day?
Yeah, it's actually the last one I recall. It was the 12th of July, and I had had a long day at school and wanted to relax a little bit before I had to go to Sacramento in the morning. So I went to this place called Joe's Tavern, because they never check for ID. I started drinking around 11:45, stopped a bit after 1, then I left and got a bit of rest before I hit the road for Sacramento at 6. I wasn't on the road for very long, though. This motorhome got in my way all of a sudden.
I'm sorry, Mr. Levette. Did you say a motorhome got in your way on the road?
Unfortunately, yeah. One second it wasn't there, next second it was, and I've been up here ever since.
Well, thank you for joining us today, Mr. Levette. I'm going to turn to the Special Administrator of your state now, Miss Shauna Snyder. Hello, Miss Snyder. Could you please explain how you knew Mr. Levette?
Might have been my brother. All I know is I was able to be in charge of his money and property when he died, which was barely anything. So I sued the tavern and the sheriff's department and hoped that I could maybe get some more money out of it because the tavern served him alcohol. But, I also wanted justice for Daniel.
What did you sue the tavern for?
I found out that when the accident occurred, Daniel's blood alcohol level was 0.187%. He had been at Joe's Tavern that night, and apparently they knew that he was under 21 and he was going to drive to Sacramento that night, and they still served him. So I sued for negligently and maliciously serving him alcohol and breaching their contract to not serve underage patrons when they had signs everywhere saying they wouldn't.
Tell me more about that contract.
Well, they had signs all over their tavern saying that they wouldn't serve underage drinkers. So it's like a promise to the public saying that they won't serve people under 21. And they did. So boom, breach of contract.
Now, let's go over to Joseph Viani, the owner of Joe's Tavern and who responded to Mrs. Snyder's lawsuit. Mr. Viani, how did the lawsuit hold up in court?
It didn't. The district court dismissed it, and then when they wanted to appeal it to the Supreme Court of Nevada, they dismissed it too. They couldn't even prove that we didn't even know that he was under 21, or they couldn't even prove that we knew he was going to Sacramento. So it was clearly something to laugh at in the courts, and they're getting nothing.
Well, that's fortunate for your bar. I'm sure you were careful about patrons driving home for your bar after that.
You can't do that. You might be sued for false imprisonment if you hold the patrons against their will at the bar. You gotta let them make their own decisions. They're adults. They gotta do their own stuff, and we aren't responsible for anything they cause to happen after they drink, because the great old state of Nevada Supreme Court made a ruling in the early 1990s that alcohol actually wasn't the cause of any criminal or tortious acts of any intoxicated.
Interesting. Evidently, Miss Snyder has informed my team she has more to add to her segment. Let's go back to Miss Snyder.
I also sued the sheriff's department and a whole bunch of other individuals who were involved in the department and Joe's Tavern.
We'll go to the sheriff's department to explore that claim. Chief Medrosa, what was the basis of the lawsuit against the sheriff's department?
A few years ago, we implemented a policy which made it impermissible for deputies to ask for identification of patrons at Joe's Taverns. Shauna asserted that in implementing this policy, we were acting negligently and with malice. Didn't hold up in court, dismissed without any consideration or anything. I guess that'll teach citizens to sue the sheriff's department.
Miss Snyder, you appealed the decision by the district court against Joe's Tavern. Did you also appeal the decision against the sheriff's department?
Yeah, I appealed the whole case. I wanted to clarify that my action involved the sale of the alcohol to the underage patron, Daniel, not to the inebriated person. The case law hadn't made a determination about selling to people under 21. I also wanted to point out that there was a direct correlation between the sale of alcohol and Daniel's death.
Did the Nevada Supreme Court agree with you?
No, court dismissed it. They didn't get it, obviously. Specifically said Tavern keepers were exempt from liability of alcohol-related injuries because the cause of those injuries was the consumption of alcohol, not the serving of it. And the sheriff's department got away with everything because the court said not checking his ID had nothing to do with his death.
As you can see, Snyder versus Viani had no basis for relief based on the alleged tortious acts Snyder said occurred on the part of the tavern and the sheriff's department. But I wonder, it sounds like there were some opportunities missed. We'll cut to Mr. Leguio, our station's resident attorney, to explain.
Jane. In this case, there were multiple opportunities to sue for torts that were entirely missed out on. Firstly, the relatives of those killed in the accident could have sued Mr. Levitt's estate for intentional infliction of emotional distress and assault and battery. So this is so long as the court found that Mr. Levitt knew or should have known the dangers that accompanied driving intoxicated. He likely would have been found liable in this case. They also could have sued Levitt's estate for negligence, though of course that would have depended on whether the court found Mr. Levitt to have caused the accident itself and whether Mr. Levitt owed a duty to other drivers on the road not to drive inebriated. The tavern itself could have tried to sue Mrs. Snyder for defamation, though proving it would have been tough, and usually litigation is protected. Finally, there might have been a claim against the manufacturer of the alcohol that Levitt drank that night, or the tavern for serving it on a product liability basis. If the product wasn't made as designed or was especially dangerous, and Levitt wasn't warned, Snyder could have been sued on Levitt's behalf for that. Now, thank you very much. Back to you, Jane.
Well, listen up, folks, and make sure you file your suits if someone you know drinks at Joe's Tavern and finds a motorhome happen to get in their way on the freeway. Daniel, may you rest in peace. That concludes this case. Up next, a judge stops a horse from suing its owner for neglect. Stay tuned for more.